Hey everyone, Harry here to talk about the federal court's slapdown of Jeff Clark and Mark Meadows. All right, like all the other 19 defendants in total, Clark and Meadows have until tomorrow, Friday, to surrender. As Fani Willis pointed out, they could have just issued arrest warrants, but they gave everyone 2 weeks to come in. Clark and Meadows alone are trying not to come in at all. They have both moved to get the case into federal court. We know that part already. And they're saying, they were acting as federal officers. And we'll be talking more about, there's a hearing on Monday for Meadows and the like. But they ginned up a pretty cheeky argument that the federal court made quick work of. So remember, they're in state court now. That's where they are. And they made a motion in federal court. Hey, can we come over there, please? And that's something that the federal court has to determine. In the meantime, though, or before it's determined, they made another motion saying, by the way, before you figure out if we can come over there, please, can you just give us an order saying everything's on hold for us in the state court and we don't even have to show up at all and be, arrested and have the indignity that we're watching everyone go through, and we'll watch Trump himself go through later today. And the the federal court really made a pretty forceful slapdown. Clark, by the way, had done an even cheekier version of Meadows' motion. He said, it'd be so inconvenient potentially to fly down there. There's not that much time to get a flight. And could you please, said Clark, give us a ruling by 5 p.m. yesterday, literally kind of giving a deadline to the court for when it could, let the state court know that Jeff Clark doesn't have to go through this. Okay. What the federal court said is A, right, but was B, also very emphatic. You can make a motion to remove. But until you're in federal court, you're in state court. There's no provision for a federal court reaching out and actually freezing state court proceedings. In fact, on the contrary, there's a whole bunch of doctrines, and they apply very strongly where the state has a criminal case, because that so implicates its own important interests as a sovereign, that the federal court shouldn't be messing around with it, shouldn't weigh in. There are times where it has to, in fact, abstain from doing anything at all. Now, removal is an exception. If you've got a good argument for removal, fine. Then they'll go into federal court, and from there they'll be arguing even for immunity for the whole thing. That's down the line. But for them to have argued, can you just, put everything on hold for us, and we shouldn't have to go through the, technical process of getting arrested and printed, and the whole grimy mess in the decrepit Rice Street, Fulton County jail. It was a kind of, it wasn't just that it was an out there motion, but it was an attempt to really somehow separate themselves from any other criminal defendant, who of course would have to go through this. So that was the other theme of the judge's order. Look, you're in the position of any other criminal defendant. Right now, you've made a motion to a federal court saying, could we please, remove it there? But that gives me no legal authority whatsoever to actually keep you from going through arrest, or indeed anything, until he rules. If it takes a few months for him to the judge to decide on this, whatever's happening in state court is happening in the meantime. So there's just no basis for them to reach out and freeze up the state court proceedings. So it was a pretty emphatic rejection of the view, and now both Clark and Meadows will have until Friday, the last day of the 2-week period given by Fani Willis to present themselves for fingerprints, mugshot, and the whole deal. But their attempts to move everything into federal court start out not very auspiciously. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.